Good afternoon.
Good afternoon, Your
Good
Honors.
afternoon, Ron.
We are here in case number 2423, Baldwin versus Beam. This is a Zoom oral argument. Thank you both for being mindful of the fact that this is taking place by Zoom. I'm Harvey J. I'll be presiding today. I have the privilege of being joined by Judge Makar and Judge Lambert. Obviously, we're here for a purpose, that being oral argument, so it would be appreciated if you would do your best to answer our questions. Also, be aware of the vagaries of the whole Zoom format. If you would be kind enough to let us finish any questions we may have before you start to answer, we'll try to show you the same courtesy, but sometimes, as I think you both know, in order for us to ask a question, we'll need to intervene as to what you're saying. Mr. Henderson, you're here on behalf of Mr. Baldwin.
Yes, sir.
Would you like to reserve any time for rebuttal?
I'll reserve 5 minutes, Your Honor.
When you're ready, please proceed.
Your Honors, good afternoon. Again, my name is James Henderson. I represent the appellate John Baldwin, who is the defendant and the counterplaintiff in the lower court case. The appellant has essentially set forth 3 arguments to support the position that the court should reverse the orders entered on August 20th, 2018, May 11th, 2022, and July 8th of 2024, and the corresponding final judgment entered on July 30th, 2024. The primary argument, Your Honors, is that the trial court lacked jurisdiction to enter judgment on the charging lien. To that point, it's the appellant's position that the trial court lacked jurisdiction on August 20th of 2018 to enter the order that enforced the charging lien. Our basis for that jurisdictional argument is the numerous cases that stand for the premise that the notice of a charging lien must be filed or must be pursued through some sort of filing or motion with the court before there is an entry of final judgment or a dismissal of the case.
Mr. Henderson,
Yes, sir.
I have a couple of questions for you, and I'm sure my colleagues may have questions as well. But just generally speaking, well, specifically, was there any reference in this record before August of 2018 to the term charging lien?
No, sir. Not that I could see. And there was an argument made by opposing counsel that, hey, look, you would have had notice by virtue of that March 20th, 2017 hearing. But if you look at the transcript of that hearing, there is no reference to the possible or potential imposition of a charging lien. And I'll get to it.
Just make sure I understand your answer, and thank you, Mr. Henderson. As best as you know, and I know it's a big record, but there
Yes,
was
it is.
that term does not appear anywhere in this record until August of 2018.
That's my understanding, Your Honor. In reviewing the record of this case, primarily, and I'll be quite honest, I can't speak to all the underlying proceedings, given the how far back this case dates. But when I did reflect the record that dealt with the attorney's fees, the hearings regarding attorney's fees, and things of that nature where those would potentially arise, and where opposing counsel is claiming that notice was provided by virtue of the testimony, I did not see any mention of a charging lien or a lien of any sort.
What was the testimony that your opposing counsel is referring to that triggered, if that's the right word, the concept of a charging lien in this case? I guess you're talking about something happened at the March 2017 attorney fee hearing that was held after the denial of the motion for fees was reversed by this court back in February of 2017.
That's correct, Your Honor. Opposing counsel in his answer brief cites to a question directed to Mr. Baldwin that discusses the law firm billing my client their hourly rates and that the only way that Mr. Baldwin could pay is if they were successful in the lawsuit, and he is able to collect money from Mr. Idoni. And then there was a possible reference to the selling of the vehicle.
But
That's what.
he'd already been successful because he'd gotten the directed verdict and got a PCA the prior year, and I thought the mandate was issued in late 2016, early 2017. So if I understand the chronology, they had the litigation. There was never talking about the charging lien. Mr. Baldwin won, got a directed verdict. Mr. Idoni took an appeal. That got PCA'd. Your client then sought fees under the offer of judgment. The trial judge denied it. It came up on appeal. It got reversed and remanded for a hearing to assess fees. And then you had the hearing a hearing was held in March of 2017 to assess attorney fees under the offer of judgment. And it came out to about $625 or $624 and some change plus costs. That then went up on appeal. Mr. Idoni appealed that, right? And then in August of 2017, he voluntarily dismissed the appeal, correct?
That's correct, Your Honor.
So at that point in time, everything was over. The trial court litigation, there was nothing pending in the trial court. The appeal was done because of the dismissal. There was nothing going forward, right?
There was still the issue of the attorney's fees, which led to the judgment on May 25th of 2017. The amended final judgment.
Well, Idoni appealed that, and that's what he dismissed a few months later.
That's
August
correct.
Of 2017. So at that point, when our jurisdiction of the appeal land ended, there was nothing pending in the trial court for the trial judge to do, right?
That's correct, Your Honor.
And that's part of your jurisdictional argument, as I understand.
That's correct, Your Honor.
The actual notice of charging lien was filed sometime the following year by Mr. Bean.
That's correct, Your Honor. The dates we were using for reference was the amended final judgment was entered on May 25th, 2017. The notice regarding the charging lien in this matter was not filed until 15 months later on August 19th of 2018.
And again, after the appeal of the attorney fees was dismissed by Mr. Idoni.
That's correct.
So at that point, when there was a motion, the charging lien notice was filed, there was really nothing pending in the trial court. There was no reservation of jurisdiction to do anything. I mean, there might have been a reservation to assess the fees, but they were assessed. And
that's correct. There was.
Mr. Idoni appealed that. He appealed that, and then he dismissed that. So everything was dead in the water, so to speak, as of 2017.
That is our position, Your Honor. The only
well, I mean, that's what happened. I mean,
yes,
that's the chronology of events, right?
And the only reservation of fees in one of the last final judgments, the amended final judgment, would have been as it related to Mike, or I should say, Mr. Idoni, having to do his fact information sheets in that similar language. It had nothing to do with a reservation that could even be vaguely connected to the imposition of a charging lien. And again, the issue of attorney's fees, entitlement, all that had already been finalized.
Okay.
Is there any other questions on that topic? Thank you, Your Honor. And we
I do have a question, not on the topic that Judge Lambert just went through, and I think it is clear what the timeline is, and I think Judge Lambert did a nice job of synopsizing that timeline. What about the argument, though, Mr. Henderson, that this is out of the ordinary in the sense that you have a disposition related to the underlying liability case, an appeal of that, and then separate and apart from that, you've got this proposal for settlement, a fee hearing related to that proposal for settlement. What about the argument that there's no case dealing with a fee judgment situation? I know all the cases you've cited, all the cases I've seen have not involved a fee judgment per se. What say you about that?
Well, Your Honor, in looking at on that topic, there was a case cited in our brief, which is the 50CA case of Baker and Hostetler LLP versus Swearingen. And I think it's informative as it relates to that argument regarding, hey, look, this is a charging lien on a judgment and not on some, potential damage recovery. In that case, the 5th DCA found that since the judgment, so there was a judgment in that case, contained an express reservation of jurisdiction to consider both entitlement to attorney's fees and the amount, the trial court retained jurisdiction on the issue of the charging lien, even though the notice was filed after the final judgment. So that opinion suggests to me that had the issue of entitlement and amount of fees been finalized, as had been in this case, then the notice of the charging lien would have been untimely, and the court would not have had jurisdiction to address that issue.
Couldn't Swearingen, and I've got it in front of me, couldn't that be read to actually help the other side? Because there's some talk in that case about the equities of dealing with these types of situations involving charging liens. And in order to effectuate this equity, it made sense to this panel of the 5th DCA to allow the notice, even though it was never given, to essentially to have been given by virtue of the court reserving jurisdiction.
Yes, Your Honor, and I understand the argument as it relates to the equities. In considering those equitable factors, I think it is important to note that this isn't a case where Mr. Baldwin simply absconded with these settlement proceeds. He promptly paid the $200,000 based on the final invoice that he got to the law firm once he received the settlement proceeds. And furthermore, Your Honor, in those cases that discuss the kind of the equities, they go into issues of fraud or collusion. Those dealt with issues of fraud or collusion as it related to the entry of the actual final judgment. There was instances, for example, where the case, and I believe it's let's see here, the Miller v. Scobie case, where there was fraud in the sense of the prior attorney not being notified that there was this settlement agreement, which led to the entry of the final judgment. It called for an entry of a final judgment. And that was the instance of that case. So each of the cases discusses that kind of fraud and the collusion as it relates and as it pertains to the entry of the final judgment, not as it relates to a settlement that's done maybe a year or over a year down the road. It's in those instances where a notice needs to be done prior to the final judgment, because there's nothing by way of anything that the parties did, or it's been alleged that there was some sort of inequity, fraud, or any of that as it related to any of the judgments that were entered in this case.
Let me ask a question. Let me cut you off. And when we're talking about Swearingen, the chief talking about that case, in that case, the contract between the law firm and the client provided that you understand that we may secure a charging lien against real property or proceeds distributed in this case to satisfy the balance of fees owed. And I don't remember that being a topic here. And frankly, I didn't go back and look. Is the contract between Mr. Baldwin and Mr. Beamsford, did that contain similar language?
No, sir. The written retainer agreement does not contain any language regarding the potential imposition of a charging lien.
So going back through my your opponent's position is that that your client became aware of the possibility of the charging lien as a result of the March 2017 attorney fee hearing, when your client basically said, I don't have any more money to pay, and I may have to sell the Corvette to pay off what I owe. Is that the notice, for lack of a better term, that the RES in this case may somehow be responsible for paying the fees?
That is correct, Your Honor. And that's my understanding of opposing counsel's argument is that there was this notice by virtue of the testimony that was elicited at that hearing in March of 2017.
And there was nothing after that until actual written notice of charging lien in August of 2018.
That's correct, Your Honor.
And if I understand, continuing my chronological behavior this afternoon, immediately after that notice was filed, the judge in essence entered an order saying, okay, there will be a charging lien. We'll figure out the amount down the road. I mean, more
Yeah.
professional than that probably, but
Yes, Your Honor. There was a notice filed on August 18. There was a subsequent notice. There was pleadings going back and forth August 18th into the morning hours of August 19th. I believe the record reflected at some point on August 19th, an amended motion for charging lien was filed, and I think that was done by virtue of the fact that I believe had retained counsel. And then that morning, August 19th, is when this issue was heard by the lower court. The testimony elicited, I'm sorry.
if I understand, if I read something, I thought in the record here or in the briefs, there's a separate lawsuit pending between these parties for, I guess, Mr. Beam suing Mr. Baldwin for the balance of fees owed.
That is correct, Your Honor.
What does our record say about the status of that case?
It's currently been stayed pending the outcome of this litigation.
Was a jury trial demanded in that case by one of the parties? Do you recall?
I do not recall, Your Honor. I apologize.
If I could ask, I'm having a little bit of trouble understanding that this was a case involving attorney's fees that were awarded for the services provided to your client, correct?
That's correct, Your Honor.
You're not taking the position, are you, that the attorney isn't entitled to these funds? You're just taking a legal position that somehow this lien was not filed timely, correct?
Our position as it relates to this cause of action is that there is no jurisdiction as it relates to this lien.
Well, yeah,
But
yeah, the trial court reserved jurisdiction. The Baker and Hostetler case, I think, is right on point. Jurisdiction was retained on the attorney fee issue. The attorney's fees litigation was separate and distinct from the merits litigation, correct?
Correct.
There wouldn't have been any point in doing a lien in the merits litigation, given everyone understood there's going to be attorney's fees litigation, a separate independent action proceeding.
Well, Your Honor, and I'm sorry if I don't understand specifically your question.
Well,
there was a
okay. Well, let me start that. All the case law out there, perhaps except for the Baker and Hostetler case, all deal with an entirely different situation, which is where a lien is filed during the merits of the action before the judgment is entered, because the fee might come out of the client's recovery. That's not this case. This case solely has to do with the award of attorney's fees in a collateral proceeding, correct?
That's correct. It only has to do with attorney's fees.
And is there any case law that says, or any statute that says that there had to be a lien filed here as to the attorney's fees? Meaning, isn't it axiomatic that in an attorney's fees proceeding, that the attorney's fees that are recovered go to the attorney? Go to the client for the benefit of to be paid to the attorney?
Well, in Your Honor, that does go to our second point in terms
answer the question. Yeah.
Yes, Your Honor, the attorney's fees go to the attorney. And our position is that based on the billings of this, the attorney's fees did go to the attorney based on their billing records, which the billing records show only approximately about $33,000 that could be due and owing.
Well, my point is the notice here seems to me it's axiomatic. Everyone knew this attorney fee proceeding was for attorney's fees for your client, for your client's attorney. And what more is necessary?
Well, Your Honor, I don't believe it's simply axiomatic, because what the notice does, for example, in this case, and I know I'm running out a little bit of time, but an example in this case, what the notice does is it puts everybody on notice, including, and there's case law out there to this effect, that if there's a settlement down the road, that let's say the law firm handling the settlement would be on notice, would be on some sort of notice based on the filing in the court that, hey, these settlement proceeds are potentially a part of a lien property, that they're part of this charging lien. And there is case law out there that says it's that notice that allows for a law firm to potentially even go after that law firm for dispersing those funds without dealing with this charging lien. So for example, if theoretically speaking, according to the case law, there could have been a claim by Doug Beam Law Firm against the Indiana Council for dispersing the funds had they done that notice. So it's not simply axiomatic. It puts other parties on notice that to the extent there's some sort of settlement down the road or something occurs where these funds are collected, they are subject to this. They shouldn't be dispersed. And anybody that goes about dispersing them could potentially be, subject to some sort of litigation. So there isn't.
What other parties are there in this case? Who are you
There are
talking
no
about?
other. Well, I'm referring to within the record. It's referenced that there was this settlement agreement procured by Mr. Baldwin's Indiana Council, and then those were dispersed out. And I'm simply speaking to the hypothetical of had there been notice. For example, there is case law out there that if you disperse those funds, so that if you disperse those funds, you could be held liable. So I was only speaking to the point that it's not like the notice serves no purpose just because this is a fee judgment. It absolutely serves a purpose. It puts other parties on notice to the extent that this person is able to be collectible or whatever the case may be, that these funds are going to be subject to that lien, that there's an attorney out there claiming that he has some right to those funds.
Thank you.
Mr. Henderson, we have been a very active panel, which is to the credit of Judge Makar and Judge Lambert. I'm going to give you 3 more minutes for rebuttal. And I would also, if Mr. DeLeo is so inclined, I will give him 3 additional minutes as well. So we'll wait for your rebuttal, Mr. Henderson. Mr. DeLeo, please proceed.
Good afternoon, Your Honors. The evidence and testimony adduced below was that appellant agreed to an alternative fee agreement with the appellee, broke that agreement, and is now seeking a $400,000 windfall at the expense of Appellee. In 2005, the appellant was sued by Mr. Idoni over the ownership of a Corvette concept car worth several
Mr.
million dollars.
DeLeo, let me stop you there. What you just said, though, all of that can be advanced in this other action, correct? Everything you just said with the lead-in, the windfall, purported surreptitious behavior, all that can be vetted out in this separate claim, can it not?
Theoretically, yes, Your Honor. If you look at some of the cases that we cited in our brief, it talks about a preference of dealing with the issue of attorney's fees in the action in which that was actually the dispute, and not doing it in a separate action. Again, it's judicial economy. If the court for some reason reversed today, we go through the other lawsuit, potentially another couple of years, more attorney's fees on both sides, and then more than likely an appeal back up to the 5th DCA if Beam appealed again. So theoretically, yes, but again, there's cases that say it is preferable to having this decided in the original action.
Well, why would that be? I mean, well, let me I ask your opponent in the separate case that the chief is alluding to or referencing. Is there a demand for a jury trial in that case?
I don't believe there is. I can't swear to it, but I don't believe that there is.
I mean, there's no contractual arrangement between your client and Mr. Baldwin that a charging lien would be imposed. It's not in the contract itself, right?
Correct.
And so if Mr. Baldwin simply said, well, I don't have any more money to pay you. I don't agree to a charging lien that I have to sell my Corvette. I just ran out of money. If you want to sue me, and then we can litigate that in a separate case. But this post after the fact charging lien seemed to circumvent all of that when there's no contractual basis for it. And it seems to me that the basis is because Mr. Baldwin voluntarily suggested during the 2017 attorney fee hearing that he may end up having to sell his Corvette to try to pay the balance of the fees. I mean, am I missing something along the way? I mean, you might not like the lean-to from the voice I'm using, but what am I missing?
Well, Your Honor, what was stated in the 2017 hearing was a recitation of what the alternative fee agreement was between the parties before the jury trial ever happened in this case. That's, that's what the record shows, is that Mr. Baldwin told Mr. Beam, look, I can't afford to keep paying on this, and this is already several years, into the litigation. I can't afford to keep paying the fees. And the testimony from Mr. Beam was, all right, well, let's do a straight contingency then. On the outcome of the case, Mr. Baldwin didn't want to do that. So they agreed to basically a deferral of fees, where if the proposal for settlement, if they prevailed on the proposal for settlement, which in fact they did, Mr. Beam's fees would be paid out of anything that was awarded and collected. If that didn't happen, then he agreed that he would sell his interest in the vehicle. And if that didn't happen, he was still on the hook for the fees regardless.
Well, let me ask about, up until this oral modification, I'm assuming this is an oral modification you're talking about?
Yes, sir.
Okay, up until that point, the highest rate that Mr. Baldwin was billed was $300, right, per hour. Is that accurate?
I believe that's accurate, Your Honor.
Okay, so you go to an attorney fee hearing and the judge awards double that amount. And I get it, there's expert testimony, et cetera. Why wouldn't that fee judgment inure to the benefit of Mr. Baldwin as opposed to you, unless there's some written agreement that you had that says the fee arrangement we have is I will pay you the hourly rate, but if there is a court awarded fee and above that, that will be my fee. I mean, that's sort of how I understand the status of the law. And if you don't have that here, if there's nothing in writing that says that, tell me what is erroneous about the third argument being raised by the appellant that's saying, not for nothing, at worst case scenario, I owe you $300 an hour times whatever the number of hours that you've expended in this case. That comes out to I'll use lodestar figure, but let's not get Roe into this. I take that number and I minus what I paid, and that's what I would owe you as opposed to $400,000. Tell me why that's wrong.
Well, Your Honor, because Mr. Baldwin he was not obligated to pay anything under with a deferral. So when this agreement was made,
let me jump in for a second to add another factor here. So at the time that this agreement comes up that you're telling me, I guess it's 2017, right? At the attorney fee hearing that's talked about, right? Or no?
It's talked about, but it came up before the actual jury trial in this case.
So back before the case was over, before the trial was over, this was the new arrangement, is what
Correct.
You're saying.
Yes.
But there's no talking about a charging lien. There's no filing of anything at that point. I think we've all agreed as to that.
Correct.
So wouldn't that have been the time then for you to do that, or for that to have been done to say, okay, look, here's the scenario, Mr. Baldwin. You're not being able to pay me. I need to get paid. This is an expensive litigation. It's gone on for 10 years. It looks like the only vehicle, either pun or no pun intended, the only vehicle for you to get paid is the car, the sale of the car. Let's get this down in writing. Let's get this. I'm going to file a charging lien, which is not done. And now you're saying after the fact, because there is an attorney fee award and the trial judge reserved attorney fees to address basically the offer of judgment. right? And that's what happened, but there was never any discussion about reserving jurisdiction to assess fees in favor of your client against his client, against Mr. Baldwin.
Well, Your Honor, yes, could it have been put in writing? Yeah, it would have made it clearer, but still the lower court over numerous evidentiary hearings all found that this was indeed the agreement, and that the proposal for settlement, after it went up to appeal to the Fifth and came back down, that it was proper to award the fees, and there was a fee hearing on it. And I think a crucial fact in this case is Mr. Baldwin had no basis for recovery of his attorney's fees in this case. There was no prevailing party attorney's fee provision by statute or contract or anything. So the agreement was by Mr. Beam and Mr. Baldwin, okay, you can't pay me. We're going to do this. I'm willing to continue to represent you on this matter. Got a good result on it, and therefore anything that was awarded pursuant to the proposal for settlement could only go to Mr. Beam. I mean, Mr. Baldwin is not entitled to that. So in other words, he's saying I should be able to keep the $400,000. I got basically free representation at this trial in which I won, and I got, awarded the entirety of the ownership of this vehicle, and I'll pay you what I feel like paying you, but I'm keeping the rest. Well, he wouldn't be otherwise entitled to that anyways.
Well, counsel, let me ask you a couple of questions.
Yes, sir.
I'm looking at the trial court's order, which focuses on what the trial court considered the dispositive issue in the matter, which is whether timely notice was given. This is on page 7527 and 7528 of the record. And the trial judge devotes a couple pages there, a page and a half at least, to discussing the evidence in the case that establishes that notice was given, quote, in some way. I guess the standard for determining whether notice is given is a pretty flexible, equitable one. There's no magic words or magic document that has to appear to get a lien. But in the course of the proceeding, there was testimony by Baldwin that corroborates exactly what you're saying, which is that there was a fee agreement agreed to between them that was modified. Baldwin agreed he'd have to pay Beam for any judgment, which Baldwin would hopefully collect from Adoni. And this would include having to sell the car to pay Beam. This testimony is dispositive. I'm reading from the order. The court finds that Baldwin has clearly been timely notified that Beam intends to pursue his rights to receive payment, even if it requires sale of the very automobile that has been the subject of the litigation for 12 years. It goes on. And it says, Baldwin's conduct, Baldwin's testimony all supports that Baldwin clearly understands, beyond dispute, that Beam is coming for these funds. And the trial judge says that's sufficient to put him on notice. There's no case that says it has to be done in a specific way. It just says it has to be conveyed to the other side in some meaningful way. And the trial judge makes factual findings here, which I assume are supported by the record from the testimony that I've read, at least. So the court concludes Baldwin did receive timely notice of the charging lien. There's more than sufficient evidence for an imposition of a charging lien in this case, and judgment should be entered once Baldwin has an opportunity to present evidence. Isn't that the long and short of this case?
It is. It's the essential issue, I think, in this case and in this appeal.
And let me just put this in context. We're talking about timeliness of notice. This case is 20 years old. 20 years. I mean, there's nothing timely about this case. I've rarely seen a case that's dragged on for 2 decades. And the notice here, at least was during the course of the proceedings on the attorney's fees itself, wasn't it? In other words, I mean, okay. So I'm not even sure, is there a case that even says there has to be a specifically worded charging lien here when the testimony of the very party who knows that his lawyer is trying to collect a fee, knows that that's what the proceeding is about.
I haven't found any case that's directly on point with this issue, but there are cases that are cited that state the notice just has to be in some manner.
Well, let me deal with that if I may, Mr. DeLeo. And let me start by saying, and the cases are legion on this, and I think it's undisputed. But let me see if you dispute it, that this is a common law theory, a common law concept, a charging lien. So the case law dictates how we evaluate whether a charging lien is proper. I mean, you would agree with that, correct? It's case
Yes.
law, not statute.
It's a common law equitable right.
Well, and my point's a little different than that. What the cases say, Sinclair Lewis, which was a Justice Ehrlich opinion, Justice McDonald's opinion, and Daniel Moniz both say definitively that case law dictates how we evaluate a charging lien, correct?
Correct.
All right, and so let me read to you from Daniel Moniz, Justice McDonald's opinion, 1986, about 40 years ago. But what do you make of Head Notes 2, 3, and 4? In order to give timely notice of a charging lien, an attorney should either file a notice of lien, which you agree didn't happen here, correct?
Not until August of 2018.
Thank you, Mr. DeLeo. Or otherwise, pursue the lien in the original action. Was the lien otherwise pursued in the original action?
By original action, are you talking judgment on what went to a jury trial and that was a directed verdict?
Well, or in the fee event, in the original action that was a directed verdict affirmed by our court, or in the fee hearing, was the notice of lien otherwise pursued in either of those actions? Again, this is the language of the Florida Supreme Court and Daniel Moniz.
So, I mean, it was pursued in the effect that, okay, we prevailed, the proposal for settlements kicking in, we're pursuant to our agreement, Beam is going to get whatever is awarded, and that's going to be collected either from Mr. Idoni or the sale of the vehicle, or Mr. Baldwin, you're still going to be on the hook. Tell me, what is due. So yes, I would say in that situation, it definitely was pursued. Was there any disagreement between Mr. Baldwin and Beam prior to that? No. Mr. Baldwin, in that March 2017 hearing, agreed that was the modification that they had come up with, and agreed that he was on the hook for it. And
if I went through that hearing, and I must admit I haven't read every word. I read Mr. Baldwin's testimony from that March of 2017 hearing. But if I was to word search that hearing, would I find the term lien in that hearing transcript?
I don't believe so, Your Honor.
And so how could you say that there was an attempt to pursue a lien in even the second action if that term is never even used? I want to try to understand your argument given what I consider to be the black letter law of the Florida Supreme Court from two Florida Supreme Court opinions.
Well, we're relying on, Your Honor, that the requirement of a formal notice of a charging lien is not required in this case, because there's other cases that we've cited that state, well, in exceptional circumstances, the notice isn't required, and again, it can be required. It can be done in in some form of notice. It doesn't have to be in writing. It's just, an understanding between the parties that these funds that are, if they're awarded, are going to be Beam's funds and not Baldwin's funds.
Well,
And
let me ask,
especially makes, oh, sorry.
let me ask this then. All right. Let's say the $624,000 attorney fee award judgment is assessed against Mr. Idoni, like in May of 2017, I believe. If let's say there was never any further discussion between Idoni and Baldwin about this, is it your position that at that point, Mr. Baldwin owed your client the $624,000 minus anything he'd already paid? And if so, why in the world would Mr. Baldwin ever testify, ever want to increase that amount at that hearing if at the end of the day, he knew there may be a lien assessed against him for that whole amount? I mean, that seems counterintuitive. If, it's one thing if I'm sitting here saying, well, there's not going to be a lien against me if Mr. Beam gets as much as he can against Mr. Idoni, that's fine. But, if all of a sudden I'm now going to owe 624 instead of what my billed amount is, I certainly don't want to have that number at 624 if that's not my fee judgment anyways. That's where I'm kind of lost this whole concept that there's a lien for this amount. And at the very least, why this shouldn't be something that a jury trial, or as opposed to an expedited, let's do it here after the fact with no written contract that has a charging lien provision in. That's where I have a lot of difficulty with this whole process that you're espousing today, that you hope we affirm. Go ahead.
Well, Your Honor, I mean, I know it's, obviously a hypothetical, but I think that the parties would discuss that issue if that happened. But, what happened in fact was Mr. Baldwin received $600,000, didn't notify Mr. Beam, didn't otherwise have a claim to it without telling Mr. Beam that he was coming in to pay $200,000, paid $200,000. So that's all, we're getting. And I'm keeping the other $400,000.
Well, did Mr. Baldwin come in and say, okay, here's my last bill, Mr. Beam, here's your 200 grand. Thanks for all your work. Good luck.
The testimony was that he didn't even speak to Mr. Beam. He came in, Mr. Beam wasn't in the office, came in, dropped off the check with, I believe, Mr. Beam's son, Riley Beam, who's an attorney, and said, here's a check for 200 grand and left.
What was it related to a bill? I mean, did he just decide 200 grand was a figure to show up with, or was he thinking, okay, I've got a bill. That's how much I still owe the guy, Mr. Beam. I've now got money. I'm going to walk. I maybe it's not critical that he saw Mr. Beam. He came in and said, I want to pay my bill. Here's the 200 grand that I owe under this last bill. Thanks for everything. Have a nice day. I'm moving on.
I believe that the record shows that there was the last bill that she had received, which was several years old, I believe, showed an outstanding balance of 193,000 or something like that. And I believe his testimony at the evidentiary hearings, Mr. Baldwin's testimony was, yeah, I had this bill for 193,000, went in and paid the 200,000. There wasn't any testimony that I recall that he was paying that 200,000 based on, or that he told anyone at Beam's office that that's what he was basing the $200,000 payment on.
Well, it's close to the amount that his last bill was. So
Sure.
Granted, he probably didn't give you any interest that probably had properly accrued, but he basically rounded up from the last bill he had. That appears to be what happened. I mean, you weren't there, I wasn't there, but that appears to be what happened, right? Go ahead.
So I didn't know if there was any other questions. I see I have 14 seconds left, but again, this,
Mr. DeLeo, we have asked you a lot of questions. Thank you for your patience with the panel. I'll give you another minute. Do you want to synopsize your client's position?
sure. Again, there's no hard and fast rule on, the notice requirement under a charging lien. And especially in a situation where we have not the typical case here where the attorney is either withdrawn before the final judgment's entered or has been discharged before the final judgment's entered. Yes, you need to file the notice of charging lien. Here it's on attorney's fees where the dispute happened well after the fact. The third notice to third party argument, they're not privy to what the discussion is between, or the agreement is between attorney and client. Mr. Baldwin acknowledged in 2017 that was the agreement. And, to now say, well, that wasn't the agreement. I basically changed my mind and I settled with Mr. Idoni, and I think just him settling and not informing his own attorney speaks volumes to what really happened here in this case. And again, he had no other basis to claim attorney's fees. I mean, Mr. Beam stayed in this case solely on this agreement, Mr. Beam's detriment really, but he wanted to see this through. He had a relationship with Mr. Baldwin, trusted Mr. Baldwin, and then, this happens. And now they're relying on this argument. Well, you didn't file something before the final judgment in the actual trial of the case. You'd have to have a crystal ball to do that. And if the court reverses,
Mr. DeLeo, I gave you a minute. You've taken two. Thank you. Thank you for your time.
Thank you.
Mr. Henderson, rebuttal.
Can't hear you.
I think you're on mute.
I apologize, Your Honors. There's been some question about what constitutes a proper notice in the context of a charging lien. And I understand there's.
Well, let me ask you this. What is unfair about the trial judge's ruling here? He took the facts of the case and said your client clearly had notice. And it was timely because it came during the course of the proceedings. He may not have used the magic word lien. Well, what's unfair about this? Because our court has said in this very case, Baker and Hostetler, the preferred method is to have what occurred in this case versus having a quote separate action. In other words, we want to get these things resolved in the court below and not have have more litigation over attorney's fees. My God, there's already been 20 years of litigation in this matter. We're going to have another lawsuit. What was wrong with the trial judge's findings? Isn't it an abuse of discretion, a standard that we apply?
One of the things I believe would be unfair would be what has the amount of that actual charging lien. What's been discussed here is accurate. That this individual my client was billed a certain way, $300, $250 at first, then $300 an hour. He made payments throughout the duration of this pending litigation based on that written retainer agreement, based on the billings he got. The last billing.
Well, you had the chance to flesh that out in the proceeding below. There's nothing unfair about that. This is equity. This is an attorney who hasn't gotten paid, at least fully paid. What's so unfair about having this proceeding? Given the trial, tell me that the trial court's findings, show me the abuse of discretion in the trial court's findings.
Well, the notion that the attorney has not been paid is not accurate. There has been discussions about this windfall that allegedly has been.
Show me in the trial court's finding. What's an abuse of discretion in the trial court's findings? If you could address that, please.
Well, first and foremost, there was no jurisdiction, so any decision.
Well, let's assume there is
avoid.
jurisdiction. I'm asking a specific question. I appreciate a specific answer.
The abuse of discretion is the fact that this agreement would have been void as against public policy. Based on that, this would have needed to be done on a quantum merit basis, and the reasonable value of the services rendered would have been the best evidence, the only evidence of that would have been these billings that we entered into evidence. The appellant entered into evidence. Those billings showed, again, 193,000 and change due. That was the
But
last bill my
you're
client
not
received.
addressing, my question goes to the things I read into the proceedings today about on pages 750, 7527, and 7528. He made the findings about timeliness. Where is there an abuse of discretion in those findings about timeliness?
Because I don't think there was timeliness, because I don't think that
You're not answering my
a
question.
I'm sorry if I'm not, and maybe I'm not
Gotcha.
particularly understanding it. I'm sorry.
I thought it was pretty straightforward, but fine.
Anything else, Judge Maker?
Appreciate it. Answered my question, but we run out of time. I'm fine.
Well,
And-
I'll give him another minute, if you don't feel like you got an answer to your question.
Your Honor, my understanding of the question, I'll try to be brief, is that you're concerned with the timeliness of the notice, correct?
My question is on the 2 pages in the trial court's order, which we assume is correct. It comes to us with a presumption of correctness. He made these findings based upon the record before him. He said there was more than enough evidence, more than sufficient evidence to establish timeliness. And he goes through 2 pages of it in factual findings. Point out where there's an abuse of discretion in his findings.
And if I'm understanding, the abuse of discretion would be the fact that it can't be timely notice if it was only verbal, that the notice needs to be filed in the court. And if you look at the Greenberg-Trowig case, it discusses what constitutes timely notice. And in that case, there was 3 letters sent from the law firm to the clients. And the law firm came in and said, hey, look, you were on notice of this whole thing. You have these 3 letters. They were entered in evidence that were from us. What the court came back and said in Greenberg is that doesn't constitute timely notice. That's not notice. Now, if you would have filed those with the court or something to that effect, because it is a little bit lenient of what needs to be filed with the court, that could have been timely notice. So the issue is that that's what I would submit constitutes an abuse of discretion, that this could be some sort of verbal notice that wasn't filed with the court.
Thank you, Mr. Henderson. Thank you, Mr. DeLeo. It was well presented on both sides. We are in recess. Thank you.
Thank you, Your Honor.
Thank you, Your Honors.